Contracts are the cornerstone of every real estate transaction, so it's essential to understand how they function. A legally enforceable contract is valid, but what does void and voidable mean? Is there a difference? Hello everybody, it's Zach here from realestatelicensewizard.com. Today we're talking about what makes a contract valid, void, and voidable. In this video we're going to define valid, void, and voidable, talk about how it deals with real estate, and of course, talk about what you need to know for the real estate exam. Let's get started. By now, you should know what 4 requirements are necessary for a valid contract. If not, we have a full video on that. I'll link above and down below. For a quick recap, the 4 requirements are: 1. The party must be legal age of 18 or older and deemed mentally competent. 2. The contract must be legal or hold a lawful purpose. 3. A clear and specific consideration must be included in the agreement. And then lastly, 4. The contract must hold mutual consent or be agreed upon by both parties. Pretty simple, right? Now let's take a look at void contracts. This is where it gets interesting. So what are void contracts? Well, a void contract is one that lacks all or one of the elements that make a contract valid. The contract is invalid at the time of its establishment and is not legally enforceable. Void contracts are not contracts because they lack an essential element of the contract and are thus unenforceable. Now, a void contract in most situations is void because, again, it lacks one of those fundamental elements that we covered earlier, making it valid. Because it isn't legally binding or a legally binding agreement, neither party has to do anything to end it because it essentially doesn't exist. Now, this is also important to mention that because of it not existing, it loses its enforceability, meaning neither side has the right to sue or sue for failure to fulfill or anything along those lines. Now, there are some characteristics that I'm going to put on the screen for you right now that may cause a contract to be void. So obviously you can see here, maybe the contract isn't legally binding. Maybe it doesn't establish parties in a legitimate way. Maybe the contents of the contract are against the law. Those are all good examples of what would make it a void contract. Now, there are really good specific examples that I want to get into. For example, a contract to sell narcotics or something, doing something illegal, obviously that would be void since selling drugs is an illegal action. Or even something, worse than that, maybe a contract to kill. Since killing is unlawful, a contract to kill cannot exist. Another example would be if one of the parties involved maybe was legally mentally incompetent. Again, the contract cannot exist because it lacks one of those essential elements. They have to be mentally competent. So now, what are these voidable contracts? Well, a voidable contract is a legal agreement between two parties that may be unenforceable for any number of reasons. Voidable contracts have the necessary elements to be enforceable, so they appear to be valid, but can be rejected by one party if the contract is discovered to have any number of defects. Now, it's worth noting most real estate sales contracts include contingency clauses, making them voidable. So here are some characteristics that may cause a contract to be voidable. So maybe one or both parties changed their mind about the agreement, one party was duped or pressured into signing the contract and uses their right to challenge its legality, or maybe one or both parties decide to rescind the contract. Or maybe, lastly, the contract was established under duress, fraud, deception, making it voidable. So let's take a look at some voidable contract examples. So let's say you wanted to buy a house with a tree in the backyard to set up a swing for your children. Let's say you signed a contract for the house and that is supposed to have that tree in it. But you show up one day and the tree was cut down. That makes the contract voidable. Why? Because you still can buy the house, the contract still exists, you signed the paperwork, and maybe you don't care that much to end the contract. Since you have that option to continue the contract, it makes it voidable. So what's the difference between void and voidable? Well, you might have already figured it out. The terms void and voidable are frequently misunderstood and often used interchangeably. Please don't do this. They're not the same thing. A void contract differs from a voidable contract, although may be nullified for similar reasons. They have specific differences. Failing to recognize them could result in legal proceedings down the road. So again, I cannot emphasize enough. Please learn this difference. Okay, so void contracts are not contracts because they lack an essential element of the contract and are thus unenforceable. Voidable contracts have the necessary elements to be enforceable, so they appear to be valid, but can be rejected by one party if the contract is discovered to have any number of defects. See the difference? A void contract is null and void from the beginning. In this situation, neither party can enforce a void contract because it is treated as it never existed. When one party states a legal reason for canceling or revoking a voidable contract, it does not become invalid until the other party asserts a legal reason for canceling or withdrawing it. So then what is the difference between void contracts and unenforceable? You probably heard me mention this term earlier, and I want to explain that and clear things up and kind of talk about how this fits into everything. So the term unenforceable is not specific, since there are many things that can make a contract unenforceable. A void contract is more specific, as it tells us the status of the agreement. While a contract considered void is unenforceable, many contracts that are not void are also unenforceable. In other words, all void contracts are unenforceable. However, all unenforceable contracts are not void contracts. So I know that was a mouthful, so just bear with me as I give you a really good example which will clear everything up. So, most contracts need to be in writing, but not all contracts are. Some are verbal, meaning there are a few exceptions to that, classic rule. So what happens if a contract needs to be in writing but is made verbally? And let's say the agreement is perfectly legal. It follows those 4 elements, because remember, writing is not included in those 4 elements. Is that contract void? No, because it still has those 4 essential elements we discussed earlier, making the contract valid, not void. It's valid, not void, but is also not enforceable since it's not in writing. Makes sense? Remember, writing is not one of those 4 essential elements of a contract. It is required for real estate contracts because of the statutes of frauds, but verbal agreements exist, and you have to be aware of them. So now let's break everything down. What exactly do you need to know for the exam? Well, when it comes time for exam day, you need to be familiar with each type of contract. You need to know what valid, void, and voidable contracts are, and what sets them apart from each other. For valid contracts, remember the basic elements of a valid real estate contract. Remember those 4 things that we discussed. Now, if a contract lacks any of those elements or requirements, it is a void contract. Now, a voidable contract allows either party to cancel the agreement, and the contract is valid at the time of its establishment, but it may be voided in the future. Now, if you keep these basics in mind, you will have no issues with real estate contracts come exam day. And that's going to be it. Thank you guys so much for watching. I know this was a lot. This is a pretty lengthy one, but hopefully you guys learned something. Any comments, questions, leave them down below. This is Zach from RealEstateLicenseWizard.com. As always, make today magical. See you guys next time.